Aloha from Hawaii, everybody. It's time for lesson 13, chapter 14. It's over the courts and the court structure. We're going to look at the judicial process. We're also going to look at the Supreme Court in general and decision making in the Supreme Court. Alright, so when we talk about our national court system, we have a dual court system. This means that we have a national court system and then a separate court system for each of our states. The national court system has 94 U.S. district courts. Honestly, a lot of the times, you and me, we don't have a lot of experience with anything except for our local courts. We're not probably in our lifetimes going to be involved in any kind of Supreme Court case or even in the district courts. Our district courts are typically our trial courts. They deal with things involving federal labor, civil rights, social security, truth in lending, antitrust. Again, stuff that you guys probably aren't going to have any experience with during your careers. There are, though, 13 U.S. Courts of Appeals. The U.S. Courts of Appeals are, all they have is something called appellate jurisdiction. This means that parties that have lost in federal courts have the ability to appeal or rehear their case in the appellate courts. And that's an automatic appeal from the federal courts to our U.S. Courts of Appeals. Congress also creates specialized national courts to administer specific congressional statutes as well. So we have a number of different courts. So looking at a little bit of history of the judicial system here in the U.S. Originally, the colonists brought English common law to the U.S. The national judge-made law was common to the entire country. Judicial decisions tend to serve both to settle controversies and establish precedents. We've talked about precedents throughout the semester and how important they are. The president can make executive orders. The Congress can pass legislation. The power that the Supreme Court has is to set precedents. They're just as good as law or an executive order. There was a concept of judicial review that was established in Marbury v. Madison in 1803. This means that the Supreme Court can strike down acts of Congress if it thinks it's unconstitutional. So they can decide the proper interpretation of the Constitution as necessary. There are two basic types of law under the U.S. judicial system that I want you to be able to make the distinction between. There's civil law and there's criminal law. Civil law, these are disputes between private parties. This is the most common case that you or I might be involved in. We might dispute charges that our landlord gives us or something like that. That is considered civil law. Criminal law is when we have to prosecute individuals who have committed acts prohibited by the government. Most cases, if there is some kind of trial, the plaintiff is who's bringing the court trial against the defendant. So think about plaintiff, the way you can easily remember it is think about plaintiff as the person who is complaining, plaintiff, got it? And the defendant is the one who is defending. They're the ones who risk going to jail or something like that if they lose the case. In a class action suit, so I want you to know what class action is. Most of you have probably already been involved in one, whether you know it or not. This is one or more persons sue on behalf of a larger set of people. This is sometimes when you get those like $5 checks in the mail because, say you were with a certain phone company and they overcharged you and somebody brought up a class action lawsuit. There might be millions of people involved. It's not something that's done on an individual basis. It's done on behalf of a larger group of people. Judicial requirements limit the cases that a court can hear. Each court has something called jurisdiction. Jurisdiction is really easy to figure out. Jurisdiction means that there's only a certain area, either geographical or ideologically, that they can cover. Geographically, jurisdiction is easy to explain. If you think about it, the Wichita police, they only have jurisdiction in the city limits of Wichita. If we talk about the Sedgwick County Sheriff, they have jurisdiction anywhere in Sedgwick County. But if we talk about the Kansas State Highway Patrol, they have jurisdiction everywhere in Kansas. So that's geographical jurisdiction. Supreme Court and other courts have ideological jurisdiction, as well as sometimes they're limited by geography. The Supreme Court is the only court you'll ever encounter that has both original jurisdiction and appellate jurisdiction. Original jurisdiction means they can hear the original trial and make a judgment, but they can also work as an appeals court as well, and they're the only ones that can do that. Whenever you hear the term justiciability, this is a court's power to exclude certain cases from consideration. This is their power to decide not to hear something if they don't want to. Whenever we're looking at a court case in general, the burden of proof is on the plaintiff, the person who's making the complaint. They're the one who has to prove that they were wronged by the defendant. It is all on them to prove. Because remember, we've heard innocent until proven guilty. That's how our court system ideally works, which means that the defendant just has to defend themselves. They don't have to present extra evidence to prove their innocence. They have to depend on the plaintiff to come up with everything. Now, the big thing that we ran into a problem with in the 2000 election was the fact that the courts are not supposed to hear cases that involve political questions. They kind of got around it by saying that, oh, in 2000 it wasn't a political question. We were just answering how you're supposed to count the votes on the ballots. Well, that indirectly decided who the president was, and that really shouldn't have gone to the Supreme Court. That's more of a Congress thing, because they're the ones who are supposed to break ties. So before anything happens, the courts must determine the facts and establish evidence for a case. Then they can look at the legal questions. The original jurisdiction courts are there to determine facts and get all of the information, while the appellate courts are the ones that apply the facts to the relevant law. They're the ones who say, okay, here's all the evidence, here's all the laws, here's all the precedents, here's how we're going to rule it. The one thing that we're kind of running into is that Americans are becoming increasingly litigious. That means that we're depending more and more on using the courts to solve our disputes instead of just talking to each other. And sometimes you hear this called, people say Americans are sue happy. And it's because we just like going to court to settle things instead of, I don't know, finding a mediator and talking it out on our own. That can cause kind of an issue, especially because even though you might pay a fee to go to court, it doesn't cover all of the costs of court. So it's American tax dollars that end up going towards paying for those court costs. And so the more litigious we are, the more our court system is going to cost us money. So when we look at the changing nature of the Supreme Court, the early Supreme Court held very few cases and was really perceived as fairly weak because we didn't really set a lot of precedents. So we didn't say, you know, hey, this is our ability to kind of create laws through precedents because we didn't hear enough cases to set them. Marbury versus Madison, when we came up with judicial review, that's when we started gaining some power in the Supreme Court. When we talk about the Marshall Court, this is an era where we tended to affirm government policies. When you look at the Taney Court, this is an era where we protected states' rights. Rules consistently at that time favored slave owners. It was frequently at odds with the different branches of the government because they were up at north and they were trying to get rid of slavery. The Republicans tried to weaken that court by altering its composition and jurisdiction, which we've seen historically. Whenever somebody like, say, FDR isn't happy with how the court's probably going to respond to something like the New Deal legislation, he threatens to pack the court with judges who will be sympathetic to him. So, like I kind of mentioned, FDR had his New Deal economic policy. He did try unsuccessfully to pack the court with sympathetic judges, and since that was kind of a threat to their independence, the court eventually softened their opposition to the New Deal programs just to make sure that he wouldn't try to pack the court again with his own justices, or that if another president came in and continued, that he wouldn't do the same thing. Now, the Supreme Court itself, not all courts, but the Supreme Court has almost complete open jurisdiction in deciding what it's going to see. Today, most cases arrive to the court on a petition. The Chief Justice tends to prepare a list of cases the court should consider at the next meeting. The court will decide to hear a case if at least 4 of the justices decide they want to. So they don't even need a majority. They just need almost half. The court is more likely to hear cases whenever there's been a lot of information submitted and briefs to support them. They tend to focus on hearing civil rights and civil liberty cases these days. They don't hear a lot else, but you'll see stuff go from like the ACLU. We saw an earlier video this year about drug testing in schools. That's a matter of civil liberties. That's one that went to the Supreme Court. So when they're making a decision, first, after they hear the oral arguments, the justices are going to discuss and vote on the case. After casting votes, justices will write opinions on that case. There's a couple of different opinions they might come up with. The majority opinion is exactly what it sounds like. This explains reasoning behind the decision that's reached by a majority of justices. This majority opinion is what sets the precedent. This is the judgment. The justice who agrees with the majority decision, but for a different reason, can write a concurring opinion, which means I agree, but here's kind of a side note. And then there's a dissenting opinion. This is important to remember. This is when a justice disagrees with the majority decision of the court. Okay? They're going to write their opinion, tell you why they disagreed and why they don't want to see this go through. So whenever we have a plurality, we've heard that word a few times in government. It's pretty consistently defined. This is when it's an opinion on behalf of the largest block of justices, but it's less than a majority. So say there is a 4 justices that have an opinion for option A, and then there's 3 justices that have for option B, and then 2 justices, 2 justices for option C. Nobody has a majority. In order to have a majority, you have to have 5 justices agree on something out of the 9. Okay? So, if 4 is your biggest number, that just means it's a plurality, not a majority. But it's going to take place of a majority. That's what's going to establish the precedent. So, the courts, something that's unique to all of the courts is that the court itself cannot enforce its judgments, its ruling. That's why you tend to see other branches or other departments kind of pick up on that. That's why we have a lot of bureaucratic structures. If you think about it, if you go to a court case, if you watch Judge Judy or something like that, the judge is going to work completely independent. Now, if somebody is taken away in handcuffs, that's done by the Department of Justice, the Department of Corrections. They take them away from a separate point of view. They also dish out punishments separately. If you think about it, if a judge has to, I don't know, be the one who pulls the trigger on a death penalty case, like they have to pull the lever on a death penalty case, they're going to be a lot less likely to rule for death penalty because they're going to have to dirty their hands. The way we keep the Supreme Court as neutral as possible is to take that out of their hands. All their job is to do is to look at the facts and apply law. They don't have to apply this. They don't have to apply the actual sentence. They come up with a sentence, but they don't have to actually apply it. They don't drag someone away to jail, and they don't have to dirty their hands essentially. And that is in place so that we can keep the court system as neutral as possible. External factors can also influence the court decision. Congress can propose constitutional amendments to overturn court decisions. So when they make decisions on precedent, they have to be aware of the opinion of Congress at the time. They can also threaten to modify the court's appellate abilities. The president has the ability to exercise control over the Supreme Court by filling the court vacancies, which are confirmed by the Senate. They do play a key role in implementing decisions and helping develop policy. And public opinion can also influence the court. We see that even more now that we have more influence of media. Ideology itself influences the decisions of justices. A lot of the times you'll hear ideological differences on, say, the interpretation of the Constitution. Do we need to take it literally and consider it unchanging? Or do we need to consider the Constitution as flexible and adaptable to all new circumstances? So, when we consider judicial activism, this is another key word you need to pay attention to. This argues that the court should make public policy and vigorously review government policies, that they should have their hands in everything that the government does. Judicial restraint, on the other hand, it argues the court should not make policy or challenge other branches unless it's absolutely necessary. So it takes a lot of power away from the court, that it says you don't need to be dirtying your hands in everything. You just need to stay there and do your job when we ask you to. So when it comes to selection of Supreme Court justices, the president is the one who nominates replacements for deceased or retiring justices. Most nominees can be personal friends and colleagues of the president, but they have to go through an FBI background check. Typical qualifications for the Supreme Court, they're typically lifetime legal careers with good reputations. They tend to share a lot of the views with the president about policy or even party. They tend to be old enough to be prominent in their field, but young enough to be able to be on the court for a long time. The president wants to put someone who will leave a legacy in the court for a long time, not just finish up with their duties about 5 years after the presidency. Diversity in gender, race, and ethnicity is much more recent, like as in the last 30 years recent. The court has pretty much been packed with older, white, well-educated males up into the last couple decades, but now we're seeing a lot more diversity. I'd like to see it go even further with more diversity and kind of fairly represent the United States, but it's kind of hard to do when you only have a few people in the Supreme Court. So like I said, the Senate has to confirm Supreme Court nominees. Confirmation is by majority vote by the Senate. Confirmation is less likely if the opposition party to the president is the one controlling the Senate. When the court is ideologically split, or when it's late in a president's term because they think he's packing it to do a last hurrah before he leaves. The Senate Judiciary Committee is somebody who they probe and they question and they dig into each of the candidates to make sure that the nominee is going to be fit for a Supreme Court position. When we talk about lower court selection, there's a lot less involvement at the federal level. The president is typically, he might have a little bit of input or suggest at the state level, but a lot of the times he just leaves it to the state's House and Senate. Senatorial courtesy is what we call this. This is when senators from the home state of a nominee for a lower court may exercise veto power, they may make suggestions, etc. When it comes to lower court judges, political partisanship has become a lot more important for these local positions than it has been in the past. So when we are looking at civic engagement today, individuals and interest groups use the courts to shape public opinion and policy. We've seen this over the last half century. If you're just looking at, say, the civil rights movement, it's really important. The expansion of the court's role in making public policy is the product of both congressional and Supreme Court decisions. So they voluntarily, on multiple branches, decided to increase Supreme Court power. And again, they emphasize personal rights, civil liberties, civil rights in the courts today. So what I'd like you guys to discuss as a class for the remainder of the period, I want you to look at whether the Supreme Court should be able to interfere with policy, how much Congress should take up on that, how important are precedents for establishing laws for us to go by. How important is the Supreme Court, do you think, in flexibility? Do you think they're the most flexible branch, the least flexible branch? How much power do you think they should share with something like the executive or the legislative branch. Until next time, I will see you guys.